Hello and welcome. If you just want to wait for a few minutes, we'll be getting started at the top of the hour. Thank you for coming. If you need some last second coffee before we get started, make sure to do that. We're getting started here in a couple minutes. Yes, please feel free to put in the chat where you're tuning in from. We'd love to see. Wow, nice difference in places. We have some US, some abroad. We give it one more minute to let anybody else who's showing up All right, I'm going to go ahead and get us kicked off and started on our presentation for the day. So first, welcome. We are going to be talking about detention and prosecution by non-state armed groups today. So a little about myself. I am a second-year law student at the University of Texas School of Law. I have been with the American Red Cross IHL team for about 6 months now, and I am super happy to be hosting this with two amazing panelists. Just a couple features. Please make sure that you're engaging in the chat if you would like to, and feel free to ask any questions using the Q&A feature, and we'll get to some of those later on. So one thing I would like to note before we get started is the American Red Cross's fundamental principle on neutrality, and that kind of confines how we approach and talk about certain issues. So we will address that where appropriate, and just be aware of that. So I am super happy and honored to be joined by two amazing panelists. So first, I would like to introduce Ezekiel Hefes. He is a senior policy and legal advisor at Geneva Call, which is a humanitarian NGO that engages armed groups and de facto authorities on humanitarian issues. He is the author of Detention by Non-State Armed Groups Under International Law, which you can find at Cambridge University Press. So Ezekiel, would you tell us a little about yourself and about the organization you're part of?
Thank you very much, Hunter, and thanks to the American Red Cross for this invitation. So my name is Ezekiel Hefes. I'm a senior policy and legal advisor at Geneva Call. Geneva Call is a humanitarian organization that engages armed groups and de facto authorities around the world on different humanitarian issues, IHL in general, international humanitarian law, but also on child protection, on the prohibition of sexual violence and gender discrimination, on the prohibition of using landmines, protection of cultural heritage, healthcare, prohibition of starvation, And it has been doing so for the past more than 20 years. Geneva Call has engaged more than 180 groups, and many of these engagements are publicly available. So very happy to be here discussing this topic, also because it is a topic of my PhD thesis on detention by non-state armed groups that was later published by Cambridge University Press in the book. Thank you very much, Hunter, and thanks to the American Red Cross for this invitation.
And our other panelist, Lakshmini Sevaratna, is the legal advisor and head of the legal department in the ICRC, which is the International Committee of the Red Cross Regional Delegation for the United States and Canada, based in Washington, D.C. During her tenure with the ICRC as a legal advisor, she has worked in Sri Lanka, Afghanistan, Iraq, and Syria, where non-state armed groups have been a key actor with whom the ICRC has engaged in order to carry out its internationally recognized mandate. Lakshmini, would you like to talk a little more about yourself and your organization?
Thank you so much, Hunter. Can you hear me okay? Okay. Thank you so much to the American Red Cross for inviting me to represent the ICRC's view in this discussion. Very happy to join Ezekiel in this very interesting and timely conversation. So I, as Hunter mentioned, work for the International Committee of the Red Cross, which has a history of close to 160 years of existence. We are in our 159th year now. And our mandate is essentially stemming from the Geneva Conventions, where the ICRC is tasked with encouraging parties to armed conflict to comply with international humanitarian law. So we were born in Switzerland, however, with now an international mandate coming from the Geneva Conventions. We are akin to a governmental organization. So our status is that of an international humanitarian organization. We work in over 100 countries with over 20,000 staff, essentially executing a humanitarian mandate, which I'm happy to talk about as we go forward, promoting international humanitarian law, providing assistance to people affected by armed conflict, as well as affording the protection, making sure that parties afford them the protection that they are entitled to under humanitarian law. So we execute this mandate in many different ways, which I hope I'll be able to talk about as we go forward. Thank you, Hunter.
And thank you, Lakshmini. So just so everybody's aware, I've broken up this discussion into 3 different areas. So first, we're going to talk about the importance of the topic, so why it's important to discuss this. Then we'll talk about sort of the legal framework around these practices. And then we'll address the role for international actors, both states, NGOs, and other international organizations. So to get that started, I think it's important that we have a good idea of what the topic is that we're talking about. So what is a non-state armed group? So we can look to international treaty, and there isn't a single consensus definition, but we have some ideas that we can see. So in NIACs, which are non-international armed conflicts, in Additional Protocol 2, NSAG is defined as a dissident armed forces or other organized groups. And there's 3 requirements that you need to establish to have an NSAG, as we call them. 1, it has to be under a responsible command. 2, they have to exercise such control over part of the territory as to enable 3, enable them to carry out sustained and concerted military operations. AP1 has a grant of special status for national liberation movements who fight against colonial domination and exercise of the right to self-determination. And these NSAGs are afforded all the protections of IHL pertaining to IACs. But it's special to note that these are rare, and they require some sort of use ad bellum or the use of force criteria for analysis there. So that leaves us with NIACs, or non-international armed conflicts, being the main focal point here. And so what does Geneva law or Geneva Convention say about this? So in Common Article 3, which is common to all 4 of the Geneva Conventions. It starts with, in the case of armed conflict not of international character occurring in the territory of one of the high contracting parties. So this basically lays out basic or minimum provisions. And the way that you get to a NIAC is you have a non-state armed group fighting against government forces, think of the Civil War, or you can have non-state armed groups fighting against other non-state armed groups. There can also be a mix of the two, somewhere in between. This alone could take up an entire course, so I will leave it at that. But just know that there is a higher threshold to initiate an IAC. There has to be a level of intensity of violence, and there has to be a specific organization for the non-state armed groups. But once the NIAC is established, all parties are bound by IHL. So specifically here, we are going to be talking about detention and prosecutions. So what do we mean by detention? So in the literature, this is commonly referred to as deprivation of liberty. Detention refers to the deprivation of liberty caused by the act of confining a person in a narrowly bound place under the control or with the consent of a state or an international armed conflict, a non-state actor. And this is important to differentiate from POWs, which have different judicial guarantees, and especially in the context of NIACs, especially a very different organization. So by prosecutions, there's sort of two meanings that we can be talking about. One is sometimes non-state armed groups wish to assert control by maintaining law and order over the territory that they are overseeing. And so they can be doing things like a normal law enforcement of a state would be doing. There's also the second prong where they might be seeking to enforce IHL, either against armed fighters from other non-state armed groups or against government soldiers themselves. And this brings us to the fact that most of the conflicts going on in the world today are that of a non-international character, as described by Common Article 3. And so we have to really be aware of the legal and implications and trying to develop that law so that we're making sure to live up to the humanitarian purpose of our organizations. So we can see recent examples from Colombia, Libya, Syria, before the inclusion of Russia, Ukraine. We can look at Mali, Afghanistan, and so many others where NSAGs have used their organization to deprive individuals of liberty. And so it's important to look at the legality of these measures and some of the motivations for doing them. And I think that brings me to my first question for Ezekiel, in what are the NSAG commitments that Geneva Call works to provide, and what brings those groups to the table on those?
Yeah, thank you very much, Hunter, for this. So Geneva Call uses different tools of engagement with armed groups and de facto authorities. Perhaps the most famous one is the deed of commitment. This is a standardized unilateral declaration that armed groups and de facto authorities can sign, and they commit to respect certain international standards. We have developed 5 thematic deeds of commitment: one on the prohibition of landmines, one on the protection of children from the effects of armed conflict, one on the prohibition of sexual violence and gender discrimination, one on the protection of healthcare, and one on the prohibition of starvation. So it's quite interesting because this allows armed groups and de facto authorities, representatives of these groups and the authorities, to come to Geneva and sign these deeds of commitment together with Geneva Call and the Canton of Geneva. And these groups, they commit to respect international standards that are included in these deeds, and to allow Geneva Call to monitor the respect of those commitments. But we not only we promote the signing of these deeds. With some groups, we might promote the conclusion of other tools, such as, for instance, the adoption of codes of conduct or unilateral declarations, including on different humanitarian issues that go beyond these 5 thematic areas that I mentioned a few moments ago. So we use these tools as to engage the groups on international law. Some of them require the groups to come to Geneva and to sign these these deeds of commitment, but others might be done on the ground with the groups themselves, such as, for instance, by encouraging them to adopt certain codes of conduct. And just one point that I think is key is that the deeds of commitment, they actually, by signing these deeds of commitment, groups, they commit not only to certain international rules on these thematic areas, but also to prevent violations of these rules to happen and to punish violations, to adopt certain disciplinary measures when these violations actually take place. And we have so far, I think, around 70 groups that have signed one or more of these deeds of commitment. And children have been released from the ranks of the groups. They have adopted certain measures, for instance, in terms of prohibiting sexual violence and gender discrimination, or other relevant provisions in order to be in line with these international standards, including the deeds. In a nutshell, they are included in the website of Geneva Call, so you can find them there.
Thank you for sharing. So I want to start with Lakmini, and then Ezekiel can chime in when he wants, but why might these groups want to detain or prosecute individuals? Is it legitimization, a sense of justice?
Yeah, thank you, Hunter. I think before I answer that question, maybe it's also good for us to recognize that the detention can be, I mean, under international law, under international humanitarian law at least, there are two reasons why where the law allows deprivation of liberty. One for reasons that you of security interests, where you pose a threat to security, or you're deprived of liberty because you are suspected of committing a crime. So if you depart from that premise, then if you question why would non-state armed groups want to engage in detention, then of course it could be for purposes of legitimization, as you mentioned, because one way of showing control over a population is to say, we have the authority over you, we have the power over you, and also noting and recognizing that humanitarian law, whether you look at Common Article 3 or AP2, doesn't prohibit detention by parties to armed conflict, including non-state armed groups. It just lays requirements to follow in order to avoid arbitrary detention. So that purpose of control and sort of holding authority over individuals could be one thing. The other is you do want, if you are prosecuting for the purposes of prosecuting your own members of the group, you are doing that for the purposes of regulating a certain ethic or a code of conduct among your group, because you want to make sure that your subordinates follow a certain regulations and authorities. And if you look at Common Article, the commentaries to Common Article 3 of the Geneva Conventions, the law also sees at the interpretation of Common Article 3 looks at prosecution and detention as a form of executing the command responsibility, where a commander is under an obligation to make sure that people under your authority do not commit violations, and that if you were reasonably aware of that you take necessary actions to prosecute it. So in that sense, non-state armed groups also want to make sure that their subordinates are complying with the obligations under the law. And I think it also shows by extension, if you look at the perspective of legitimization, it also shows that non-state armed groups are taking the obligations seriously, and they are taking action in order to make sure that IHL violations are prosecuted and made accounted for. And on that particular point, international humanitarian law doesn't confine Common Article 3 to only states. It's to parties to armed conflict. So that means non-state armed groups have an obligation to comply with at least Common Article 3, provided you satisfy the different criteria. And therefore, it is somehow a way of showing that they are complying with IHL. So I think those are some of the reasons why non-state armed groups resort to detention and by extension prosecution.
I don't know if I might jump in actually and complement what Lakmini said. I think just to complement one of the points that I think she raised is that armed groups detain for different reasons and different categories of individuals. So I'm gonna share some of the findings of my research, but this is of course in my personal capacity because it's part, as I said, of my PhD thesis. But you have armed groups controlling territory and acting as de facto authorities. You have, I mean, the ICRC has identified that you have between 60 and 80 million people living under the exclusive control of non-state armed groups. So you have some detentions that are for criminal reasons, for everyday life crimes. You know, in the same way as states do. You have armed groups detaining for the commission of common crimes. You know, so you have an individual living in a village controlled by a non-state armed group that has committed murder or has stolen something, has mugged, and that individual may be actually detained for the commission of common crimes. Then you have detention of enemy forces, and this could be in the context, for instance, of the fighting. You know, they are in an open fight against the group and they're detained because as a result of the hostilities. A third category could be the detention of the armed groups members by the armed groups actually because of crimes, for instance, violations of international humanitarian law, but also for other disciplinary reasons. You know, this is actually foreseen in some of the codes of conduct that armed groups have adopted. You might have also groups detaining for financial reasons. You know, they are committing hostage taken or you know, they're asking for ransom. So just to highlight, you know, adding to what Lakmini said, that legitimacy, of course, is a factor, but it depends on the type of detention that we're dealing with. So one thing is the relation with the local population in the context when armed groups actually control territory and population. The other one is in relation to the conflict where they're detaining enemy forces in the context of hostilities. The other one is with respect to their own forces for disciplinary or criminal reasons. So when just again, adding that when thinking about the reasons why armed groups detain, it's obviously important to differentiate what type of detention we're speaking about and what type of category of individuals are being detained.
Wonderful. So why should the international community, other states, international organizations, NGOs, the general public, why should we care and engage on this topic?
Would you like me to start?
Sure.
So I think, I mean, we will come to it later in the discussion, I hope. But one reason why I think, one very clear reason why international organizations and states should encourage that detention by non-state armed groups is not arbitrary is because the law requires it. International humanitarian law, Common Article 3 and also AP2 requires that certain safeguards be implemented and certain that there should be a legal basis by which armed groups detain. So there is no prohibition, but there are requirements that need to be followed in order for non-state armed groups to detain and prosecute. Now, then the question is, why are there safeguards? And as the ICRC, during our dialogue with non-state armed groups, this is the point that we try to emphasize. And in my own work in Syria and Afghanistan, for example, what we try to emphasize is that there's not only you ticking a box by complying with the law, there's also the importance of ensuring that these safeguards, you offer these safeguards to the people who are arrested and detained. So there's value in not only being perceived as complying with the law, but also that the safeguards are afforded to the people that are in your control. So one is that legal obligation, and that legal obligation, I would say, has two parts, because if you look at Common Article 1 to the Geneva Conventions, there is that aspect of respect and ensure respect for international humanitarian law. And if you look at the commentaries to the Geneva Conventions and Common Article 3, it does say that the obligation of ensuring respect for international humanitarian law is an obligation that states have to apply not only in international armed conflicts, but also in non-international armed conflict, because Common Article 3 is part of the Geneva Conventions. So therefore, if in the context of that and in the spirit of respecting the convention, that obligation extends to non-international armed conflict and thereby non-state armed groups. So there's that legal piece to it. And then there is also, as a constituent element or a foundational element of the law, there's also the humanitarian standard that applies, or the principle of humanity that applies in international humanitarian law. Even if you don't look at it as a legal obligation, there is a humanitarian aspect to it that requires certain safeguards be applied when you're detaining a person or prosecuting a person. And if you step back from the international legal domain, and if you look at the foundational principles or the codes of ethics, or even religious concepts that some of these armed groups are driven by or base their conduct on, those codes of ethics or those religious precepts also speak about these standards. So there is a way in which we can encourage compliance to these standards, not only by relying on law, but also on humanitarian principles, which is something the ICRC tries to do quite a bit, and I'm happy to talk about it later on. But Ezekiel, I'm sure you have things to complement that with.
Yeah, perhaps in less than a minute, because I know we have a few questions to address. I think it is important to recognize that armed groups detain individuals. So these individuals are placed in a situation of vulnerability. I mean, they are in situation. I mean, a detention facility by a non-state armed group in a conflict-affected area is not the comfort. They are not placed in a comfortable situation. On many occasions, these situations are mobile in nature because of the nature of the conflict. So it's not necessarily a proper building with all the facilities that the state detention facility may have, if I may say that. So these individuals are protected by international humanitarian law. We're going to speak about this in a few moments, but they are protected. In parallel to that, there is a prohibition of arbitrary deprivation of liberty in international humanitarian law. So it's not that all detentions, as like Minnie said, are prohibited. They're only those that are arbitrary in nature are prohibited. So the question to address is, okay, how we can differentiate between detentions that might be arbitrary in nature and detentions that might not be arbitrary in nature, and how we actually work towards those that are not arbitrary in nature, because in the end, the goal is to protect individuals who are in detention or might be detained by the non-state armed groups. So it's to provide us as much as we can, as much as it possible, to protect those individuals.
I think that's a perfect segue into our next section, where we'll be talking about the legal framework of both detention and prosecution. So I'm going to start with Ezekiel. You've written, as you said, your thesis, and you've done a lot of research in this area. What does IHL say about detention by non-state armed groups generally? You can think about Common Article 3, AP2, customary international law, whatever is appropriate.
Yes, thank you very much, Hunter, for this question. So I would say there are different sources that apply to non-state armed groups in the context of an armed conflict. I mean, of course, we have the most basic one is Common Article 3 that applies to every non-international conflict. And there you have specific rules regarding the protection of people who have been placed in detention. But these are minimum rules. Of course, Common Article 3 encourages parties to a conflict to adopt special agreements. They might include through these special agreements other relevant provisions, including the Geneva Conventions. But this is a basic principle, is that people in detention, because they are not participating in the conflict, they have to be protected. And this is in Common Article 3. Customary international humanitarian law also contains certain provisions related to the protection of detainees, but also related to detention in general. So you have, for instance, the prohibition of arbitrary deprivation of liberty has been recognized as being customary in nature by the ICRC in its study. But also you have other rules, for instance, the principle of legality. It is included as part of in the context of the customary study of the ICRC. So you cannot be, you need the law to undertake certain activities. And this is essential. when thinking about certain detentions conducted by non-state armed groups. And then you have additional protocol 2 that complements Common Article 3 in certain specific situations. So Common Article 3 applies, for instance, to conflicts between non-state armed groups. Additional Protocol 2 applies between the armed forces of a territorial state and an armed group located in that same state. And then you apply Additional Protocol 2, and in the Additional Protocol 2, you have further provisions regarding the protection of individuals in detention. And it's interesting because Additional Protocol 2 differentiates between detentions that are related to the conflict and detentions that might not be related to the conflict. So in short, you have these 3 bodies of law, if you want. So customary international humanitarian law, Common Article 3, and an Additional Protocol 2. And perhaps just to add one more thing, because I think this has gained some momentum in the last few years, is the role of international human rights law. So the ICRC, for instance, for those non-state armed groups that are highly organized, so-called de facto authorities, has recognized in the commentary that they might incur into human rights law responsibilities. So you might have armed groups that are highly organized that might be detaining, for instance, for reasons that are not related to the conflict. And then the application of international humanitarian law might be a bit more difficult, and you might need to bring international human rights law. So I'm just saying this because, of course, when we think about non-state armed groups and we think about armed conflict, the first port of call is international humanitarian law. But for certain entities that are highly organized, it might be worth also discussing the possible application of international human rights law, in particular in relation to individuals in detention, but also with respect to the prohibition of arbitrary deprivation of liberty that is also contained in international human rights law.
Thank you, Ezekiel. We have a follow-up question I want to ask you. So what judicial guarantees do NSAGs have to provide to detain? So from my understanding, there's in the sense of like arbitrary detention, there should be some sort of ability to contest the detention. Is that something that the law here provides for?
Yeah, I mean, you have in some of these provisions are included in customary international humanitarian law, but here, but it's specifically related to prosecution, administration of justice, but non-state armed groups that I think Lalvini is going to develop in a few moments. Perhaps the key point here that I would like to highlight is that, so as I said, there are different types of detention, and one position is that Lalvini correctly mentioned before. One position by the ICRC, for instance, is that there are certain detentions of which the ground of detention can be found in international humanitarian law. And as she said, there are 2 types of detention, and you have security detentions, and you have what is called internment. So it's like you're detaining for security reasons. And one position is that international humanitarian law provides a legal basis to detain those individuals. Although it has said that it needs to be complemented by additional legal authority. This is what the ICRC has said. So, but you know, there are other views, and this is the view that I highlight because I have interacted with groups specifically on this, is that the legal basis to intern, so it's like this detentions conducted in the context of security and for security reasons. So when they detain, for instance, enemy forces, is that international humanitarian law actually is silent about the legal basis to detain, and that you need to explore this additional legal authorities. Okay, where can you find the legal basis to detain for these groups? And of course, states might rely on their domestic law, or they might rely on other sources. And this has been a discussion before in terms of whether UN Security Council resolutions can provide a legal basis to detain or not. But for non-state armed groups, it's much more challenging because, of course, you know, you never have a UN Security Council resolution authorizing an armed group to detain an individual. So the question is whether international humanitarian law provides that legal basis, or you need to look for something else. My research has shown that most of the armed groups that detain, they rely on their own laws to conduct detentions. So you talk to the groups, and when you ask them, you know, what are the legal basis to detain, and they rely on their codes of conduct or laws that they have adopted or other tools that they might have at hand. So what I'm saying this in connection to your question is that, of course, international humanitarian law contains some of these rules in terms of prosecution, administration, justice, but we don't need to neglect the possibility of armed groups adopting their own laws or adapting some of the laws that are that are applicable in the country, or for instance, like Minnie mentioned, religious concepts and religious values. Some groups follow Sharia, and yeah. Anyways, I'm gonna stop it here.
That was really helpful. So I'm going to turn to Lakmini so we can get a better view on what IHL says about non-state armed groups that pursue prosecutions.
Thanks, Hunter. Yeah, and I completely agree with what Ezekiel said. And I think the question then, Ezekiel, is what should those codes of conduct or laws that non-state armed groups want to come up with, in what shape or form should they be, for them to satisfy the legal basis criteria and the framework criteria that is required under IHL and human rights law. So to answer your question, Hunter, I think if you look at Common Article 3 and then you look at the protocol, Additional Protocol 2 of 1977, which came years later, there's a slight difference in the way the requirements are worded, because Common Article 3 talks about a regularly constituted court to issue judgments and to prosecute persons in relation to a non-international armed conflict, whereas whereas Additional Protocol 2, Article 6 talks about the court's ability to issue judgments, to operate in an impartial and independent manner in order to offer fair trial guarantees. So then it goes back to the point that Ezekiel mentioned, which is, what are those fair trial guarantees? And if you look at the commentaries to the Geneva Conventions, it gives a list of requirements that are also part of customary international law. So these guarantees, the guarantee of being presumed innocent, to be able to have your own defense, access to and to be tried by a fairly constituted court, a reasonably constituted court, and to be tried at a reasonable time frame, and so on and so forth. So you can find these sort of extracted, if you will, from Article 75 of Additional Protocol 1 or human rights law obligations. So these are the fundamental guarantees that one would think of in terms of a fair trial. But then, so the conclusion then is, as long as you are able, you as a non-state armed group are able to offer these guarantees through a legal basis and legal framework that Ezekiel was talking about before, and conduct those trials as per the standards that you lay out in the law, then you are able to, the law doesn't prohibit you from carrying out prosecutions. But then I think what we also have to be realistic about is, how far are these trials so conducted by non-state armed groups accepted by a state? I mean, is it important to be recognized by a state? There are instances it is, because it has practical consequences. So, for example, if a person is, let's assume a person under being detained in northeast Syria, an Iraqi person who is detained in northeast Syria is prosecuted by the trials that are set up by the non-state armed group that is operating in the context and has control over this person. And then eventually this person is transferred to Iraq to be repatriated. Is the state of Iraq then obliged to recognize that the non-state armed group that tried this person did so under certain guarantees, through a court that afforded the essential safeguards, and therefore Iraq is not going to now prosecute this person? But that, and if the answer is no, then is that a fair conclusion? Because I ask this, and I offer that as a consideration, because in my reading of the commentaries to Common Article 3, and Ezekiel, please, I'd like to hear your views on this. It doesn't oblige states to recognize the ways non-state armed groups are trying carrying out these prosecutions. So I think that's an important element to also bear in mind.
A quick follow-up on that. So what are some of the minimum guarantees for fair trials that these groups have to follow if they decide to? So what might IHL say? As Ezekiel mentioned, there's some overlap here with international human rights law. Where might that come in?
Yeah. So, the first thing is to recognize that there's no prescribed list. There are certain fundamental guarantees that one would think of, but there's no prescribed list as such that you have to tick the boxes on. So one important thing would be that the person be tried by an independent, constituted sort of court and judges that are independent and impartial, to be tried without delay, to be presumed innocent before being tried and sentenced. To be able to not to be compelled to testify against oneself, to be able to offer a defense in oneself with the support of legal counsel. These are some of the basic standards that the law looks at, but not necessarily prescribing as such, I would say, under Common Article 3 or human rights law. It's drawn from these basic fundamental guarantees that you find under international human rights law and humanitarian law.
If I may jump in, yeah,
absolutely.
no, I'm sorry. No, I was going to say, I was going to pick what Lakmini was addressing before in terms of the obligation of the states. I mean, I think, of course, I agree with you that states, in the end, they don't have an obligation to recognize this. I think it is actually explicitly recognized in the commentary of Common Article 3. But perhaps, again, going back to one of the points that I mentioned before is I think we need to differentiate the type of prosecution that we're being dealt with, So it's different. I think the recognition might be different if we're speaking about a non-state armed group that is, for instance, prosecuting one of its members for violations of international humanitarian law, that if the group is prosecuting a civilian for a common crime, or the armed group is prosecuting an enemy force, a member of the enemy forces for so-called the violation of the anti-terrorist law, as it is in the case of Northeast Syria. So I think the acceptance of either the territorial or a third state might be different according to the type of prosecution, but they are not in an obligation to recognize the legal effect of these trials. That I agree with you, Lakmini.
So, given that there's a wide diversity among what we mean by non-state armed groups, they obviously have different priorities, different agendas, different levels of organization. What is the spectrum of responses by these groups to IHL? So from my understanding, there's some that are super willing to adhere, and then there's the complete opposite where groups want to ignore IHL because they view it as like state-made law. So I wonder if you have any thoughts on that. Either.
Should I go? I go for okay.
Sure.
I think it's a very good question. I think I would like, they're different. I mean, I think first of all, non-state armed groups have, there's no one straightforward answer. I mean, non-state armed groups have different perspectives with respect to international humanitarian law. It's not that you have one group of groups that accept international humanitarian law as a whole, and another group of groups that reject international humanitarian law as a whole. So it's much more nuanced, I would say. So you have groups that, for instance, yes, they come up publicly saying like, we endorse international humanitarian law, we try to apply international humanitarian law in public statements. You also have groups that accept some of the rules of international humanitarian law, but not other rules of international humanitarian law. I've been in touch with groups that tell me, listen, we very much agree that civilians shouldn't be attacked and in line with international humanitarian law. But when you start discussing the minimum age of using or recruiting children in hostilities, then it starts getting a bit more complicated. So, or again, you have groups that, they have a different interpretation of what civilian actually means. So it's a bit more nuanced. I mean, yes, and I would say in any case, you have groups that see international humanitarian law as a Western creation and imposition, but that doesn't mean that they disrespect every humanitarian value that we know of. They might find sources in different places. It could be religious, it could be local customary sources, but not necessarily international humanitarian law. So I'm just, again, in a very brief explanation, saying that the scenario is much more nuanced. So yes, with that, yeah.
I can only reinforce that. I think and to reinforce the fact that the incentive to comply with IHL may come from different reasons. And even if you, I think and this is something that I can definitely speak for the ICRC as being as something that we are very conscious of, not necessarily to talk about these safeguards in the form of a legal obligation under the Geneva Conventions, because you can also find the same safeguards in the codes of ethics or the religious precepts that these armed groups are guided by. And if you, for example, if you look at the ICRC's work that you can find online in relation to the links between international humanitarian law and Islamic law, or what Buddhism says about precepts, fundamental principles of international humanitarian law, these are some of the ways in which we have tried to speak about the obligations that bind non-state armed groups, in a language that is more palatable to them, rather than rather than give them the excuse to, as Ezekiel was saying, to say that it's a Western construct and therefore this doesn't apply to us. So rather to say there may well be things that precede the Geneva Conventions by centuries, where your religion, your codes of ethics will endorse the fact that these are good practices by which non-state armed groups should operate. So I think I fully agree with Ezekiel that there's a whole spectrum of compliance and reasons, but I also think that it's how we approach the issue and how the prism through which we look at compliance that determines whether we think they're complying or not.
Yeah, and one more thing of this is that armed groups are dynamic entities. It's like at some point in the conflict, they might be open to discuss certain rules. At another moment, they might not want to discuss those rules at all. Commanders may be arrested, they might be killed, they might decide to leave the group. So when trying to assess the behaviors and activities of armed groups, we have to consider that they are dynamic entities. They change in the conflict. The FARC fought for more than 50 years in Colombia. So thinking that the FARC would be the same in the 2000s as it was in the 80s, or when it was approaching the conclusion of the peace agreement, is not the right way of picturing the activities of the groups.
Can I add one more thing, Hunter? Sorry, I just remembered something important. Just to say, apart from the fact that, apart from what triggers their compliance, I think also an important thing to consider is who do you speak to in a non-state armed group to encourage compliance. Now, for example, in Iraq, I know this very well because I accompanied some of these discussions where we approached the religious advisors to armed groups to talk about IHL and how these standards are not necessarily going against their thinking and their codes of conduct. So I think one way in which to encourage compliance and lack of non-resistance, if you will, by non-state armed groups is to find the right way to talk about these obligations with them, and not necessarily by way of talking to the commander and saying you need to do this because you're bound by the law to do so. Sorry, I'll stop there.
No, it was wonderful. I love the back and forth that we had going on there. It was enlightening. I want to aim this next question at Lakmini because you talked about it a little earlier about Common Article 1. So what are the sort of proactive steps that a state needs to take to ensure compliance with IHL before a conflict, if there are any?
In relation to non-state armed groups, or broadly speaking?
Broadly speaking, and then you can narrow in if appropriate.
Right, I'll try to be brief because I see that time is running out. So Common Article 1, the commentaries to Common Article 1 of the Geneva Conventions, if you look at it, it talks about a positive and a negative obligation falling on states to comply with this obligation. Positive being to do what is within you, reasonably in your power to take measures to correct violations of IHL, and the negative obligation being not to encourage violations or assist violations of IHL by other states or armed groups. And in brief, I should also say that this is an obligation that extends to non-international armed conflicts, and by extension of that to non-state armed groups. And therefore, it's an obligation that states carry with them under international humanitarian law. Now, that's what the law says. Now, what do you have to do in relation to make this work? one way where the ICRC has really learned and shared our observations with states by observing things on the ground and over time is to say, especially when you're in a relationship of partnership with a non-state armed groups, there's also the predictability of a conduct of hostilities, and that detention is a result, is a very natural and predictable consequence of conduct of hostilities. And so you can prepare a non-state armed group to that eventuality, to share good practices, encourage them to foresee that if you are going to engage in conduct of hostilities, then you will most likely than not have people that you will come into your custody, arrest them, detain them, and you might even want to prosecute them. So that's something that is foreseeable, and then to prepare or take steps to ensure that the non-state armed groups are prepared for this eventuality. And then there could be instances where within the resources that is available to you as per the Common Article 1 obligation, you may be able to build the capacity of non-state armed groups, where you're training them on what are the good practices and standards by which you can detain people under your control. Now, that's a sort of the higher end of the things that you could do. But then there are also other things that states do, which is you provide arms transfers, you provide training, you engage in conversations. There are multiple ways in which states have a relationship with a non-state armed group. So there are, if you look at the commentaries, it gives a list of the types of support that states can offer, be it to a state or a non-state armed group, depending on who your audience is, to encourage compliance. And not only to encourage compliance, but where things are going wrong, to discourage the continuation of that and to take action. So for example, if you are in the process of building capacity of the non-state armed group, you could condition your support by saying, we will not support you as long as you are violating the law. And then you withdraw your support as long as you know the non-state armed group is violating the law. So for example, in the United States, you have domestic law that encourages this kind of practices. So these are a very quick answer on what states, what may be at the disposal of states in complying with Common Article 1.
Wonderful. So we're going to move on to the role of international actors, and we've been touching on this throughout the discussion. So I think we can move forward at a decent pace. But one thing that I am aware of is the risk that some of the such as your organizations face when entering discussions with groups like these and being labeled terrorists by some certain states, or demands by states for sovereignty over their soil. How do you overcome some of those risks, or how do you balance those when just going to engage in these groups? You can speak broadly, of course. Ezekiel, you can start, and then we'll go.
I go. So there are a few things. I mean, the first one is to recognize that international humanitarian law allows impartial humanitarian organizations to engage all parties to the conflict, to non-international conflicts, including non-state armed groups. So this is explicitly mentioned in Common Article 3. So IHL provides the legal basis for that engagement. That's the first step in the equation. The second one is from my perspective, is when engaging armed groups on issues related to the application of international humanitarian law, you're not legitimizing the goals of the group. You're just saying that you're responding to a factual situation. There is an armed conflict. There is a level of organization. There is a level of violence. They have obligations. So this is a framework, actually, that should limit the activities of armed groups, of what they cannot do. They cannot do whatever they want. So international humanitarian law provides that framework. So you're not legitimizing their goals or the motivation of the groups. You're just pointing out the fact that they have obligations and there is a framework that limits their activities. And again, you have, I'm going to quote some of the numbers that the ICRC has provided, but you have more than 600 groups that cause humanitarian concern around the world, and around 100, this is what the ICRC has said, that are parties to armed conflicts. So not because you label them as terrorist organizations, they're going to disappear or they're just going to stop causing a humanitarian concern. They're going to be there. So there are different ways of addressing their activities. One way is, of course, as I said, is to directly engage with them. for them to understand what their legal obligations are. In any given society, the circle of people who's aware of the law is very small. The circle of people who's aware of international law is even smaller, who's aware of international humanitarian law is even smaller, and who knows the differences between international humanitarian law, international criminal law, international human rights law is even smaller. So we think that non-state armed groups, because they are parties to the conflict, they know their international obligations. They know what they can not do. They are prohibited from doing. This is often not the case. They don't know their obligations under Common Article 3. They don't know their obligations under customary international humanitarian law. So if we want them to respect IHL, the first step is actually to sit down and discuss about IHL with them. Otherwise, it's very difficult to ensure compliance with this body of law because they don't know the obligations. Again, I'm making a generalization here because I understand that some groups may respect certain humanitarian values, not because of IHL, but because of other sources. But again, we need to sit down and have a discussion about the application of these rules with all parties to the conflict.
Lakmini, anything to add? I know the ICRC has unique circumstances with this in terms of how the media reports on certain things and how that causes some PR issues. So if there's anything you would like to add on how the ICR handles those risks in discussion.
Yeah, that's a really important aspect, Hunter, because the ICRC is the cornerstone of the ICRC's working modality is confidential bilateral dialogue, which means we speak to parties to conflict, be they states or non-state armed groups, confidentially and bilaterally based on information that we have collected ourselves, and not based on sources that we cannot verify ourselves. And in order to have that kind of confidential bilateral dialogue, first of all, you need to gain the trust of the parties to the armed conflict. Now, of course, it's slightly easier when it's a state because the law is clear. There are forums whereby states are brought to account for how they comply with their obligations, which are more, I would say, robust and more has been around for a longer period of time, and therefore the ICRC is able to sort of have that kind of engagement a little bit more easily, but not necessarily always easily. But it becomes slightly even more complicated when it comes to engagement with non-state armed groups. Why? Because more often than not, to reach a non-state armed group, and I mean it in the broadest sense, reach physically and reach a dialogue, requires us to get into a country first, which means the state has to allow us access and acceptance, and then to get to the actor itself. So there are somehow a two-step process, which gets it to be a little bit more complicated, and that then depends on our mandate, which as I said at the beginning is an internationally recognized one, whether it is understood by the state and the non-state armed group. Why are we, so that the state doesn't question, why are you going and talking to the non-state armed group who is fighting with us? And are you now siding with the non-state armed group? So it's a perception issue. And this boils down to ICRC's neutrality and the fact that ICRC reaches or tries to reach all parties to armed conflict, because our mandate is to encourage compliance with IHL by all parties. So it's trust, reaching into access, and then it also touches on our own staff being able to carry out our mandate in a safe and secure environment. So somehow the confidential dialogue is a very important cornerstone in the way the ICRC operates. But I would not, my answer would not be complete to say if I didn't say that there are drawbacks to that, because our reports are never public. We don't talk about, we don't name and shame parties to say this particular thing was done by this particular party and therefore these are the consequences. We might publicly communicate about a situation in order to communicate about the humanitarian consequences, but we never name and shame or we don't publicly advocate for compliance. That doesn't mean those who are doing that are doing wrongly, but ICRC complements that kind of work by engaging in a different way. And we believe that that creates a privileged space for the ICRC to approach the actor and through that, and build the trust in order to finally reach the people who are under their control and are affected by armed conflict, because that's the ultimate goal of the ICRC, not just to talk to the actor and tick the box, but to be able to reach the people who are affected. So that has its challenges, has its advantages, as well as disadvantages, I would say. That's the reality.
All right, so I think we only have a couple more minutes, but I think there's an important question that I have, and that is, how has social media changed how engagement works? Is there any room for using those systems to communicate or engage or raise awareness within these groups?
Okay, I go first. That's another very good question. It has changed in different ways. I mean, the first one, again, it really depends on the group. I'm making generalizations here, but you have groups that actually use social media for different purposes. They use social media to promote their goals. They use social media to recruit individuals. They use social media for to put forward certain views that they may have on certain topics, political, but not only political issues. So it is a platform that armed groups also use on certain occasions in certain places, right? Again, in some places they don't have internet, or the access to some of these platforms is limited. So it is something that is being dealt with from the side of the groups. In terms of the humanitarian perspective, you see also an increasing number of international humanitarian and local civil society organizations active in social media, promoting humanitarian values, promoting issues related to the application of international humanitarian law in armed conflict. And this is because it's part of the dissemination goals. You want everyone everywhere to know that there are these basic principles that need to be respected, even in armed conflict. So, and again, social media can be the platform for this. So it's a way of rethinking traditional ways of disseminating information. It's not just lecturing in a university, but also is developing short videos that can be used on Twitter, that can be used on Instagram, that can be used on TikTok. I don't know, and is that towards that goal? Everyone everywhere should know that there are these basic rules that need to be respected, even in times of war.
Any last comments, Lakshmi?
Fully agree with Ezekiel, and just to caveat that by saying, for the ICRC, because we give primacy to our confidential bilateral dialogue, social media complements that in terms of disseminating and sort of sensitizing on the general principles, but doesn't replace the confidential dialogue for us. But fully agree with Ezekiel on the value of sensitizing on these principles on a broader scale.
All right, I want to personally thank you both for joining us for this engaging discussion today. I apologize to those who asked some amazing questions that we weren't able to field those, but please feel free to send those to our email. If Thomas could send that out, that would be great. And please feel free to send any questions, comments, or suggestions to, I believe it's ihlaw@redcross.org. And we will be happy to answer any of those questions. You can see it pop up there, but thank you again. Go and have a wonderful day, and hope you learned something. Have a good one. Bye, y'all.
Many thanks.
Thank you very much to everyone.